Hello, everyone. Welcome to today's session on agency relationships. Now, before you start thinking this is just another dry legal lecture, let me tell you, this topic is everywhere. Have you ever hired a real estate agent to help you find a home? That's an agency relationship. Have you ever asked a lawyer to represent you? That's also an agency relationship. Have you ever told your friend, hey, can you grab me a coffee? Boom. That's an agency relationship too. The difference is in business and law, these relationships come with serious responsibilities. And if things go wrong, the consequences can be huge. Today, we are going to cover what an agency relationship is and how it's created, the different types of authority an agent can have, the legal duties and responsibilities of agents, how agency relationship ends. So, yep, that's it. All right, let's get started. So this presentation will give you a solid foundation in agency relationships. We will talk about actual and apparent authority, the general duties and fiduciary responsibilities of agents, liability and termination of agency relationships. By the end of this session, you will not only understand the legal rules, but also how they apply in real life business scenarios. So, what exactly is an agency relationship? An agency relationship exists when one person, called the agent, is authorized to enter contracts or act on behalf of another person, called the principal. Now, let's be clear. This authority is powerful. It means the principal can be legally bound by what the agent does. That's why businesses and individuals need to be very careful about what they grant agency powers to. Some common examples include real estate agents negotiating contracts for home buyers and sellers, corporate executives making financial decisions for a company, employees signing deals with suppliers for their employers. The key point is agency, it's all about authority. If the principal grants the agent authority, the agent's actions can create legal consequences for the principal. Now let's talk about how this authority is created. For someone to legally act as an agent, they need to be granted authority by the principal. Now, here's the interesting part. This authority doesn't always need to be in writing. It can be formal, like a written contract saying, I authorize you to act on my behalf, or also informal, like a business owner implying that an employee can handle customer transactions. But what happens if someone just assumes that they have authority? Well, that brings us to the next section, types of authority. First of all, actual authority. This is when the principal explicitly or implicitly gives the agent the power to act. There are two types of actual authority. Number one, express authority, and number two, implied authority. Let's break them down. Express authority is when the principal clearly and explicitly states what the agent can do. For example, a CEO signs a contract authorizing a manager to approve purchases up to $100,000. Or a law firm hires an attorney and explicitly states that they can negotiate settlements for clients. This kind of authority is the safest and most enforceable because it's clear and documented. But not all authority is this direct, which is where implied authority comes in. Implied authority is when an agent has the power to act based on the role, even if the principal didn't explicitly say so. For example, a store manager can fire employees because it's part of their job. A finance director can approve budgets because it's expected in that role. However, express authority overrides implied authority. So if a principal specifically tells an agent not to do something, implied authority won't protect them. Apparent authority is different. It's about what a third party reasonably believes, not what the principal intended. Here is an example. If a company allows an employee to sign contracts for months and months and then tries to claim that the employee had no authority, the court might say, too bad, you made it look like they had authority. That's apparent authority. Apparent authority is tested by asking, would a reasonable person believe this agent had authority based on the principal's behavior? If the answer is yes, then the principal is bound by the agent's actions. Now that we know how agency works, let's talk about an agent's responsibilities. Agents have legal obligations under Canadian law, including duty of care. Agents must act carefully and avoid negligence. Following instructions, agents must comply with the principal's directions. No unauthorized delegation. Agents cannot assign their duties to others unless explicitly permitted. Keeping accurate financial records. Agents must document all transactions. And lastly, full disclosure. If the agent has any personal interest in a deal, they must inform the principal. Example, a real estate agent cannot sell a client's home for $500,000 when the client instructed them not to accept anything below $550,000. Another example, a financial advisor who is careless and makes a bad investment could be liable for the principal's financial losses. Failing these duties can result in lawsuits, financial penalties, and even termination of the agency relationship. In addition to general duties, agents owe fiduciary duties to the principal. These are higher obligations based on trusts, including confidentiality. They must protect private business information. Avoiding conflicts of interest. They cannot act for both parties in a deal without consent. No personal gain. They cannot take business opportunities meant for the principal. For example, if a real estate agent finds an undervalued property, they cannot secretly buy it for themselves. That would be a breach of fiduciary duty. No competition with the principal. An agent cannot start a competing business while representing the principal. So here's a real-world example of no competition. A senior manager at a tech company develops a new software idea during their employment. Instead of presenting it to their employer, they quit and launch their own startup based on the idea. That's a violation of fiduciary duty because the opportunity belonged to the employer, not the agent. Violating fiduciary duties can lead to lawsuits, financial penalties, but in this case, even criminal charges. Now, what happens when an agent makes a mistake or goes beyond their authority? Agents can be held personally liable under the following circumstances. Number one, breach of contract. If an agent violates an agency agreement, they can be sued for damages. For example, a real estate agent agrees in writing to only sell homes for a commission of 5%, but they secretly negotiate a 7% commission. That's a breach of contract. If an agent acts negligently or dishonestly, they can be held liable for damages. For example, a financial advisor invests a client's money recklessly, causing massive losses. If the advisor failed to act with due diligence, they can be sued. Number 3, breach of warranty of authority. If an agent claims to have authority they don't actually have, they can be personally responsible for any damages caused. For example, an intern at an advertising firm pretends they have approval to sign $1 million deal. If the company refuses to honor the contract, the third party can sue the intern personally for misrepresenting their authority. Agency relationships do not last forever. They can end in several ways. So here we have by notice. Either the agent or the principal can terminate that relationship by giving notice. The second one is by contract expiry. If agency is based on a contract, it ends when the contract expires. Then by death or mental incapacity. If the principal dies or becomes mentally incapable, the agency relationship automatically ends. And then by bankruptcy. If the principal goes bankrupt, the agent can no longer act on their behalf. Here's an example. A sports agent represents a famous athlete under a 3-year contract. At the end of the contract, the agent no longer has authority to negotiate deals unless a new agreement is signed. So to wrap up this topic, let's go over the key takeaways. Agency relationships exist when one person, the agent, is authorized to act on behalf of another, the principal. An agent's authority can be actual, express or implied, or apparent. Agents owe duties of care, loyalty, and fiduciary responsibility to their principals. If an agent acts outside their authority or breaches their duties, they can be personally liable. Agency relationships can end through notice, contract expiry, incapacity, or bankruptcy. So, agency law is powerful. It can bind people and companies to legal contracts, create liability, and protect business relationships. Understanding agency law means you will never sign a bad contract or let an unauthorized person commit you to something unexpected. And if you ever become an agent yourself, remember, with great power comes great responsibility. So now let's move on to the next topic. So now is the moment to dive into partnership law, a fundamental area of business law that governs how partnerships are formed, managed, and dissolved. Understanding these principles is crucial because partnerships are one of the most common business structures in Canada. So, by today, you will be able to identify when a partnership exists, to understand the relationships between partners, to recognize the liabilities that partners face, then to explain how partnerships end and what happens in dissolutions, and finally differentiate between general partnerships and limited liability partnerships, or LLPs. So partnerships in Canada are regulated primarily by provincial partnership acts, such as the British Columbia Partnership Act and Ontario's Partnership Act. Each province has variations in how they govern partnerships, but the fundamental principles remain similar across the country. So let's begin with how partnerships are formed. A partnership is formed when two or more persons carry on a business in common with the intent to generate profit. In Canada, we choose the objective test from the BC Partnership Act, which considers the following elements. First, contribution of capital. Each partner brings something valuable, money, resources, or expertise. Then, sharing of profits. Profits are divided among partners unless otherwise agreed. Then, sharing of costs and losses. Partners also share expenses and potential losses. And finally, participation in management. All partners should have some level of control or say in decision making. In the case of Continental Bank Leasing Corp versus Canada 1998, the Supreme Court of Canada clarified that a partnership exists when the substance of the relationship meets the partnership criteria, regardless of what the parties call it. This case highlights the importance of reviewing economic reality rather than just written agreements. So here's an example. Imagine Alice and Bob open a bakery together, investing equal amounts of money and agreeing to split the profits and decision making. This meets the legal definition of a partnership. However, if Alice is simply financing the bakery while Bob runs it without shared management, this may not be a true partnership. Now that we know how partnership is formed, let's discuss the relationships between partners. The relationship between partners is defined by certain rights and obligations under provincial partnership legislation. Unless agreed otherwise, Canadian partnership law assumes the following. Number one, profit and loss sharing. Partners split profits and losses equally unless a partnership agreement states otherwise. Number two, management rights. Each partner has a right to participate in running the business. And number three, access to records. All partners have access to financial and operational records. In Bachman versus Canada 2001, the Supreme Court ruled that the existence of a partnership is based on substantive actions, meaning partners most actively participate in a business. So, for example, if three partners run a marketing agency and one partner starts making decisions alone without consulting the others, this could lead to disputes. That's why a partnership agreement is crucial. It allows partners to set specific terms. Let's now move to one of the most important aspects, and that is liability. Liability of partners. One major drawback of a general partnership is unlimited liability. Let me explain you. They would have personal liability. Partners are personally responsible for business debts. They would also have unlimited liability. If the business cannot pay its debts, creditors can go after the personal assets of any partner. And collective liability. Each partner is responsible for the full debt, not just their share. According to the Partnership Act of Alberta, even if one partner incurs debts without informing others, all partners can still be held liable. This is known as joint and several liability. Here's an example. If a general partnership running a construction business gets sued for $500,000 due to negligence, each partner could be held fully liable, even if only one partner was responsible. This is why some businesses opt for a limited liability partnership, LLP, which we will discuss shortly. But first, let's explore how partnerships come to an end. A partnership can end for several reasons. Number one, a partner resigns. Number two, a partner dies. Number three, a partner loses capacity, like mental incompetence, for example. And number four, a partner becomes bankrupt. Under default rules, the partnership dissolves automatically. However, many partnerships draft agreements to allow the business to continue even if a partner leaves. Here's an example. If two doctors run a clinic together and one retires, the default law might dissolve the partnership. But with a well-written partnership agreement, the business could continue operating with the remaining doctor or bring in a new partner. According to the Ontario Partnership Act, partners can agree in advance that the business will continue even after a partner exits. Now, let's discuss a special type of partnership that limits personal liability, the limited liability partnership, or LLP. So, an LLP is a special type of partnership that allows professionals and businesses to limit their personal liability while still operating as a partnership. So, in this slide, you can see the key features of the LLPs. Partners are not personally liable for the negligence or misconduct of other partners. LLPs must be registered under provincial laws, such as the Ontario Limited Partnerships Act. LLPs must include LLP in the business name to notify the public of the liability status. For example, a law firm in British Columbia registers as an LLP. If one partner commits malpractice, the other partners are protected from personal liability, unlike in a general partnership. Now, let's compare liability differences between LLPs and general partnerships. The biggest advantage of LLPs is the limited liability protection they provide to partners. So let's break it down. Number one, they are not liable for the negligence or wrongdoing of another partner or employee, the partnership contract breaches. But number two, they're still liable for their own negligent or criminal acts. Number three, still liable if they knew about a wrongful act and failed to prevent it. In VDO Dunwoody versus Canada 2004, an LLP accounting firm was sued for a partner's negligence. The court ruled that only the negligent partner was personally liable, reinforcing the LLP's limited liability benefits. Since LLPs involve regulatory compliance, let's discuss the record-keeping obligations. To maintain LLP status, businesses must comply with specific record-keeping and reporting obligations, including maintaining a list of current partners at the registered office, filing an annual report with a provincial registrar, ensuring accurate financial records to meet tax and legal requirements. For example, a Calgary-based LLP fails to submit its annual report. As a result, the registrar revokes its LLP status, exposing its partners to unlimited liability until reinstated. Now let's examine how an LLP can be dissolved. Dissolving an LLP requires careful legal steps. Here's a typical process. First, giving notice, so any partner can issue a formal notice of dissolution. Second, registrar notification. The LLP must notify the provincial registrar. Number three, winding up, that is, the LLP must settle debts and distribute remaining assets. And finally, the registration. The LLP ceases to exist after regulatory clearance. For example, if an LLP fails to comply with dissolution requirements, partners could face legal disputes over unresolved debts. So, to end this lesson, let's summarize the key takeaways from this specific topic. So, partnerships are created when two or more people carry on a business together for profit. General partnerships expose partners to unlimited liability, while LLPs offer limited liability protection. Partnership agreements help define rights, responsibilities, and business continuity plans. LLPs require registration and compliance with record-keeping regulations. And finally, understanding these rules helps businesses minimize risks and operate legally. So, folks, that's all for today, and I hope to see you on our next class.